there in the region of Chester. Let's deal with one of the big news stories today. Plans to hold more court hearings in secret have been revised following criticism from civil liberties groups and some senior Lib Dems, including the Deputy Prime Minister Nick Clegg. A proposal by the Justice Secretary Ken Clarke to allow inquests, for example, involving sensitive intelligence to take place in private, well, that particular one has been dropped. And Mr Clarke said the plans had been refined and improved. They're not happy to talk in terms of U-turns. But a former Director of Public Prosecutions, Lord Ken MacDonald, has said today that in his view, the concessions do not go far enough. So to explore this area, and it is a very important debate that's going on, Adam Wagner is in the studio, barrister with me, editor of the UK Human Rights blog. Adam, good to have you with us. Thank you very much. And we have Professor Anthony Cleese, who's Director of the Centre for Security and Intelligence Studies at the University of Buckingham. Anthony, good evening to you.
Good evening.
Thanks so much for joining us. Adam, I'll start with you and ask you basically to address one point made by quite a few commentators today, and they say this basically: yes, OK, these concessions are welcome to some people, but you know, the bulk of the changes are still there, they're unaffected, and more changes needed. Is that your perspective?
When these proposals were initially brought out by the government, they were analysed by pretty much every lawyer and organisation involved in the field, and almost every single one of them said these are very, very problematic and there are significant issues which need to be resolved. Now, arguably, almost none of those criticisms have been addressed by the new proposals.
So the new proposals, at least you concede that they are concessions?
They certainly are concessions, yes.
Anthony, what do you make of the changes today? How significant are they?
Well, I don't think they are very significant, and in a sense Lord MacDonald is right from his perspective that not much has changed. The really important thing to understand, though, is that we want to have effective secret services, and in order to be effective they need to be secret. The proposals that Ken Clarke is putting forward mean that there is an additional safeguard of accountability, because at the moment no Secret Service officer can be compelled to give evidence in a court. The new law is going to make that different. You are going to have to give evidence, but it's going to be in a closed court, in secret. But that's right, because you can't have a Secret Service and not have secrets. What's more, it's basic tradecraft that you should not disclose who your agents are in the field. We saw a very damaging example of this coming from the United States just a couple of weeks ago. And also, it's absolutely vital that if people are to have trust in their secret services, they will need to have the United States of America continuing to feed happily into the intelligence products that we use in this country. And unless we were to make sure that the evidence given in court remains secret, the Americans would simply have nothing to do with us.
Well, let's deal with the American point, because I was going to bring it up and Anthony's brought it up for us. Does that colour the logic here? What do you make of that, and is that a valid case?
Well, it's based on an assumption which has been almost rubbish by everybody that looked at these proposals. And the assumption is that under the current system of what's called public interest immunity, there are secrets being disclosed left, right and centre, or even that there's a threat of secrets being disclosed. And in reality, that's not the case. And one of the fundamental criticisms of these proposals has been that the government has not made the case, it's not presented the cases where it says it's had to settle them because otherwise there's a threat that national security would be compromised.
Anthony, is that a fair point?
I don't think it is. I mean, I think what Adam fails to understand is that the way it is at the moment, the Secret Services are less accountable than they would be under the new proposals. And there's no way you're ever going to compel any Secret Service officer to be totally open about what they do. Now, I can understand the argument that you shouldn't have secret services. I think it'd be very dangerous, but I understand the argument. What I don't understand is this legalistic view that the secret services should be castigated for, as Lord Neuberger put it a couple of years ago, be castigated for being devious and dishonest, when actually they're paid to be devious and dishonest in order to keep us all safe.
OK, Adam, on that point.
Well, I'm not sure that. I think there's different kinds of deviousness and dishonesty, and the kinds of cases of rendition and torture which are being brought against the government are not the good kind of deviousness and dishonesty. That's not what they relate to. But fundamentally, at the moment, if a Secret Service member wants to give evidence in court, they can do it anonymously. That is perfectly possible under the current system. There's no difference in terms of the dangers to their revealing their identities.
But their evidence is given, whether anonymously or not, that's not the point.
But the fundamental problem is that under the new system, only one party in the case is allowed in the court, and that's the government. We run an adversarial system of justice. That's what our justice system is all about. That means that on the one side is one party, on the other side is the other. They challenge each other, and then the judge makes a decision. Under the new system, only one side is allowed into court. Not only that, but the press and the public are excluded too from the entire hearing. Whether that leads to more or less scrutiny is a matter for Parliament, but it seems fairly sensible to assume that unless there is a very significant danger to national security under the current system, that should not be justified or allowed.
Anthony?
Well, I think the really important thing to remember is that part of the new legislation makes accountability more present. The other part deals
how does that
with
work? How does that work?
Well, because at the moment, intelligence officers don't have to give an account of what they do in court. They will in future, albeit in secret. But the second really important point is that in order for the public to have faith in their secret services, in order for the secret services not to be thought to be out of control, we need oversight. And this new government legislation sees much stronger oversight being brought in. And that is very, very important. At the moment, the Intelligence and Security Committee is next to useless. If you think of the Iraq War, if you think of the London bombings, and then you realise how many other people, from Lord Butler to Sir John Chilcot, have had to inquire into the things. In recent weeks, Sir Malcolm Rifkin, the chairman of the Intelligence and Security Committee, has been conspicuous by his absence from the debate on this. So these two things together should help accountability, but still give us the effective secret services that we need.
OK, Anthony, a final word to you, Adam. If you were asked today, look, for more changes to this package of measures, specific changes, what would you say? What would they be?
Well, the criticism, the proposal made by the Joint Committee on Human Rights was simply to amend the current system so that there's a presumption in cases where a judge has to decide whether evidence is admitted or not, that national security is important. And the other point that they made was, and I think it's absolutely right, is that in the current system there's something called SIAC, which is where cases of immigration involving terrorism and national security are heard. They can quite straightforwardly hear the judicial reviews, which under the current proposals would be included in the new system. And I think that there's not been a compelling case made yet for doing otherwise.
I can guarantee one thing, we'll return to the subject. Anthony Gaze, good to talk to you, and Adam Wagner, good to see you through. Thank you very much. Thank you both.